Welcome to this module of the Wisconsin Critical Care Paramedic curriculum, in which the medical, legal, and ethical aspects of critical care interfacility transports will be discussed. Upon completion of this module, the critical care paramedic student should be able to recognize basic legal issues pertaining to critical care transports, identify federal and state laws governing interfacility transports, explain the respective roles, duties, obligations, and responsibilities of the transferring facility, receiving facility, interfacility transport service, and the critical care paramedic, summarize EMTALA and its requirements as they apply to the interfacility transferring of the sick and injured, differentiate the various types of advanced directives available within Wisconsin, and explain ways to minimize legal liability and exposure while providing interfacility transport services. To begin, as this is a presentation on the legal aspects of functioning as a critical care paramedic, it is necessary to ensure the purpose of this presentation is clear. First and foremost, nothing within this presentation should be considered as legal advice. The information provided herein is for the purposes of educating critical care paramedic providers on the legal and ethical aspects of their jobs. Information is provided based upon general legal concepts and broad overviews of the law. If faced with a legal quandary related to the practice of critical care medicine, the impacted individual or entity should seek the advice of a qualified, licensed attorney. While this presentation is provided online and therefore does not provide a means of interaction between the student and presenter, it is important to realize that if this presentation were provided in a face-to-face or other live environment, such as through an online meeting, teleconference, video conference, or otherwise, the instructor-student relationship does not create an attorney-client relationship. There is no attorney-client privilege. The instructor owes no fiduciary, confidentiality, or other duty to the student, and any information shared by the student to the instructor or the class is not protected by the attorney-client privilege. As previously mentioned, this presentation provides an overview of broad topics of law that impact critical care paramedics. It does not address specific nuances of laws, nor does it cover legal information that is commonly included within other underlying EMS education, such as that provided within an initial EMT or paramedic program. Also be aware there is no guarantee that this presentation is all-encompassing of all the laws that may impact a critical care paramedic in the performance of his or her duties. The presentation is designed to discuss the most common laws that impact critical care paramedics in compliance with the objectives defined within the Wisconsin Critical Care Paramedic curriculum. Related to the width and breadth of law discussed in this presentation, it is also important to keep in mind that the information presented is current as of the date this presentation was recorded. If pertinent laws are added or changed after this date, this presentation will obviously not capture those additions or changes. Court decisions can also impact laws and how they are applied in certain circumstances. Case law developed after this presentation was generated may have an impact on the validity of the information provided within this presentation. While efforts will be made to maintain this presentation, providers should not rely on the presentation to provide the most up-to-date information on any specific topic. When discussing case law, it is important to recognize that the outcome of a case will turn upon the facts of that case. This means that a single law may be applied differently by the very same court to two separate cases given differences in the facts associated with each case. Again, this presentation is designed to cover broad generalities of the law and will not discuss what if or other hypothetical situations that would require a court's opinion. If a court case is discussed, be aware that a similar case may not have the same result given different facts, different parties, and a potentially different court. Lastly, the information provided within this presentation is specific to critical care paramedic practice within the state of Wisconsin only. While much of the information provided may very well apply to other jurisdictions and states to varying degrees, especially when federal laws are discussed, such correlation or similarities cannot be assured. If watching this presentation for practice in a state other than Wisconsin, it is absolutely imperative that the critical care paramedic ensure familiarity with the applicable laws within his or her specific jurisdiction. Ultimately, this presentation is not designed to make anyone an expert on the various legal topics that impact critical care paramedics. If a service or provider is ever faced with a legal issue or challenge, it is imperative to seek the assistance of a qualified licensed attorney. To begin the discussion as to the medical, legal, and ethical aspects of critical care interfacility transport, it is important to understand just what laws have specific application to the profession. We will start simply by identifying some of these sources of law. The significance of these laws will be discussed in greater detail later in this presentation. While EMS is typically governed by state law, there are some federal laws that have a significant impact on the transport of critically ill and injured patients, the most predominant of which being EMTALA, the Emergency Medical Treatment and Active Labor Act. As a potential critical care provider, reimbursement for services may not be at the top of your thoughts, but it is still a very important subject for your employer as Medicare reimbursement rates fluctuate based on the type of service provided. Beyond these two federal laws, the main laws governing the practice of critical care medicine exist at the state level. Within Wisconsin, these laws include State Statutes 256, which governs emergency medical services, 154 and 155, related to advanced directives and powers of attorney for healthcare, and 157, which covers the disposition of human remains and organ donation. These statutes were written by the state legislature prior to being signed into law by the governor. Given the nature of the legislative process, it can be a very difficult and political matter to have statutes written, enacted, or modified. Unless a statute is deemed unconstitutional by a court, it takes another act of the legislature to either change or remove the statute. Admittedly, these statutes were written by legislators who are not subject matter experts in the fields of critical care medicine or EMS. To address this concern, the legislature has authorized the Department of Health Services to promulgate rules that provide specific requirements related to these fields. Specifically, as they relate to this presentation on the medical, legal, and ethical aspects of critical care interfacility transport, the Wisconsin Department of Health Services has developed and published regulations to further define the requirements for EMS licensure, certification, and training through DHS 110, in addition to regulating the use of advanced medical directives as they apply to emergency healthcare personnel under HFS 125. While there is a formal rule-writing process that must be followed, it is typically easier to modify administrative rule than it is a state statute. Within the regulatory functions of administrative agencies, such as the Wisconsin Department of Health Services, there is also the ability to incorporate other published reference documents into rule. While a formal process must be followed to modify such a document, having this ability provides greater flexibility and responsiveness than a regulation or statute, which is commonly much more difficult and time-consuming to change. In this particular instance, the scope of practice documents published by DHS are very important as they define the skills that can be performed by EMS providers within the state based upon their level of licensure. Lastly, national standards are not necessarily law, but they commonly serve as the basis for other elements that relate directly to legal duties and obligations for critical care paramedics. If there is an area of critical care paramedic practice that is not defined or regulated by a specific law, national standards will be used by courts when evaluating the reasonableness of a critical care paramedic's actions. Given the potential of civil liability for negligent acts, nationally recognized professional standards can prove to be just as important as actual laws when defining the rights, roles, and responsibilities of EMS professionals. While Wisconsin State Statute 256 provides legislation governing emergency medical services within the state, the law that truly defines the duties, rights, and responsibilities of EMS services and providers is Administrative Rule DHS 110. Provisions within DHS 110 that apply directly to the critical care paramedic level include DHS 110.34, 110.38, and 110.39. DHS 110.34 lists the responsibilities of EMS service providers. Related to critical care paramedic is DHS 110.34 sub 16, which mandates that services must refuse to respond to interfacility transport requests by a hospital for an emergency transfer that is dispatched through a 911 center if that service is not licensed to provide interfacility transports. Interfacility transports, by the way, are defined within DHS 110.04 sub 37 as any transfer of a patient between healthcare facilities or any non-emergent transfer of a patient. DHS 110.38 governs interfacility transport services in particular. In addition to other requirements, services licensed to provide interfacility transports must ensure the interfacility transports do not interfere with 911 responses, assuming the provider is responsible for providing 911 emergency services to an area. This also means that the service cannot utilize mutual aid agreements to cover its service area while providing an interfacility transport. The service must ensure proper staffing based on the acuity of the patient, the orders of the sending physician, and the requirements in DHS 110.50. Lastly, if the interfacility service also provides 911 services, it must have at least 2 ambulances, one for interfacility transports and one for 911 response. The service can have only 1 ambulance if it has an agreement in place with a neighboring provider that can physically provide separate ambulances for both service areas simultaneously. DHS 110.39 has provisions related to critical and specialty care transports. Only services at the paramedic level can seek to become critical care or specialty care transport services. The service must designate the specialty services it offers and must also identify its schedule of availability for those services if they are not provided 24 hours a day, 7 days a week. The service shall maintain protocols consistent with the Wisconsin scope of practice for the critical care paramedic level. Ambulance staffing must be appropriate for the acuity of the patient as designated by the sending physician and in conformity with the staffing requirements in DHS 110.50. Any EMS personnel who are part of the service's interfacility transport program must be appropriately credentialed. Lastly, the services must also meet other requirements as specified by DHS. It is important to note that interfacility transports are defined in rules separately from critical care and specialty care transports. It is not necessary for a service to be credentialed to the critical care paramedic level to provide interfacility transports. The critical care paramedic level is only required when providing critical or specialty care transport services. How to determine the difference between the two will be discussed in just a little bit. DHS 110.50E addresses staffing requirements for critical care ambulances. At least 1 member of the crew must be credentialed to the critical care paramedic level. The other crew member may be licensed at any other EMT level, which would exclude the Emergency Medical Responder EMR level. The critical care paramedic must remain with the patient at all times during care and transport if any critical care paramedic skills or medications are required or used. When DHS 110.39 refers to other requirements as specified by DHS, one such example would be the information provided within the DHS EMS Numbered Memo Series 12-02 from July 2012. This is the document that established the differences between paramedic services and critical care paramedic services. Prior to DHS 110 rule revisions in 2010, critical care paramedic did not exist as a credentialed level in Wisconsin. Once a level was created in rule, DHS had worked to phase in an implementation plan for critical care paramedic services. The deadline date for that phase-in was January 1, 2013. Prior to that date, interfacility transport services were provided by paramedic-level services without the need for any specific critical care paramedic credentialing. Effective January 1, 2013, any interfacility transports that required critical care paramedic skills required the use of a critical care paramedic service. So what exactly is a critical care paramedic skill? Essentially, those are any skills defined in the DHS Critical Care Paramedic Scope of Practice document that are not also included in the DHS Paramedic Scope of Practice document. Some examples include variable setting ventilators, CVP line monitoring, and Foley catheter insertion. As the scope of practice documents are updated by DHS periodically, it is incumbent upon the critical care paramedic to be familiar with the skills that are or are not within his or her scope of practice. This list provided within this presentation may not be accurate as changes occur over time. Medications are a little bit of a different beast when compared to skills because new medications are being developed on a regular basis, making it impossible to create a comprehensive list of what would be considered a critical care paramedic medication and what would not. Additionally, the State EMS Board's Physician Advisory Committee discussed medications at length, and the general consensus is that no one medication in and of itself is outside the paramedic scope. Rather, it is the delivery of multiple medications at a single time to manage very sick patients that differentiates the critical care transport from the more standard interfacility transport. Essentially, paramedic services can transport any patient on any given medication so long as each respective medication is defined within the paramedic services operational plan that is on file with DHS. This means that the paramedics must also have training regarding that specific medication. If the paramedic service is asked to transport a patient with a medication that is not within their operational plan, they are allowed to do so on a one-time only basis so long as the paramedics receive just-in-time training on that specific medication from the healthcare facility prior to transporting the patient. After that one transport, the service must either update their operational plan to include that medication, or they are required to refuse the transport of future patients who are receiving that medication. With that being said, it is possible for the hospital to have a nurse or physician ride in the ambulance along with the crew to manage the patient if a critical or specialty care transport must be made and the critical or specialty care ambulance is not available. EMS providers have both legal and ethical responsibilities to their patients, their employer, and, by extension, their medical director, and the public at large. Aside from legal requirements inherent in activities related to avoiding civil lawsuits and liability, DHS 110.13 does define professional responsibilities in general for all EMS personnel within the state. These include the requirement to be appropriately credentialed within the state, which includes maintaining advanced cardiac life support certification if at the intermediate or paramedic level, to function within the appropriate scope of practice for his or her level of credentialing, and to follow the protocols established by his or her service. As an aside, the EMS professional must also ensure his or her contact information is up to date with DHS. Beyond the specific requirements denoted in law, the critical care paramedic is also recognized to hold a duty to other interested parties, including their patients, their service, and by extension its medical director, and the public at large. Of those three, the most important duty is owed to the patient. The critical care paramedic owes a duty of competency to the patient. This means that the critical care paramedic knows not only how necessary medical equipment works, but also how to troubleshoot that equipment in the event of a failure. The critical care paramedic must maintain a high knowledge base as it applies to the practice of critical care medicine, and he or she must constantly seek continuing education as medical science continues to evolve. Along those lines, DHS 110.07 1C6 requires the critical care paramedic to complete 48 hours of paramedic refresher training every 2 years, plus an additional 24 hours of critical care paramedic continuing education within that same time frame. As with all other levels, current credentialing in healthcare provider CPR is required, and the critical care paramedic's underlying paramedic license also requires that a current ACLS certification is maintained at all times. Ultimately, the critical care paramedic must also be able to critically think, to observe and collect fluid and sometimes rapidly changing patient data, to process all of that information in the context of his or her knowledge and experience for the purpose of developing and implementing a patient care plan, to consider alternative care if the patient fails to respond or the patient's condition worsens, and to also recognize when medical control should be contacted for guidance and online orders. Unlike the bulk of routine EMS transports, the critical care paramedic is often assured contact with critically sick and injured patients. While all EMS providers share in this duty to their patients, the critical care paramedic's responsibility is often more profound and, for lack of a better word, critical. When functioning in the field, all EMS providers are licensed and credentialed under the authority of a state licensed physician. The EMT functions as an extension of the service's medical director through the use of both offline and online protocols. It should therefore come as no surprise that law defines specific requirements for EMS services and their respective medical directors. As far as critical care paramedic is concerned, the medical director approves the credentialing of critical care paramedics, the medical director defines their protocols, the medical director determines the topics for continuing education, the medical director is involved in continuous quality improvement activities, and the medical director is also required to consider the withdrawal of an individual's credentialing with a service if the individual has engaged in conduct that is dangerous or is detrimental to the health or safety of a patient or members of the general public. An interesting facet of being a critical care paramedic is that the critical care paramedic routinely takes orders from physicians other than their respective medical director, namely the physician at the originating facility. This is permissible by recognizing that a service medical director is not expected to be available 24 hours a day, 7 days a week to provide online medical control. Rather, services and their respective medical directors are required to ensure online medical control is available in accordance with its operational plan and protocols. Assuming the service's protocols and operational plan are drafted correctly, the critical care paramedic service can recognize the originating physician or healthcare facility as its online medical control during the critical care transport. Lastly, it was mentioned that a medical director can revoke an individual's credentialing with a service if the EMT engages in conduct that is dangerous or detrimental to the health or safety of members of the general public. This duty obviously extends beyond the patient to include virtually anyone the critical care paramedic may encounter on a regular basis. The critical care paramedic has an ethical responsibility of selfless service to everyone, not just his or her immediate patient. In 1986, Congress enacted the Emergency Medical Treatment and Labor Act, EMTALA, under the Consolidated Omnibus Budget Reconciliation Act, COBRA, to ensure public access to emergency services regardless of the individual's ability or inability to pay for those services. Before the passage of the law, it was not uncommon for hospitals to practice what was known as patient dumping, where the hospital refused to treat patients if they were unable to pay for the services. If a hospital receives any payments through Medicare, it is required to comply with EMTALA's provisions. To begin, EMTALA was designed to address emergency care only. Patients with non-emergent conditions can be denied access to hospital care under EMTALA. With that being said, hospitals with emergency departments must first provide a medical screening examination for the patient to determine whether or not an emergency medical condition exists. This screening cannot be delayed while the hospital determines whether or not the patient can pay and commonly consists of reviewing the patient's triage record, initial vital signs, oral history, physical examination, appropriate diagnostic tests, use of on-call physicians, and vital signs prior to discharge. Once the screening is completed, if the patient has an emergency medical condition, the hospital is required to treat the patient as it would a patient who is fully insured or able to pay for the treatment. The treatment must be provided until the condition is resolved or stabilized. If the hospital does not have the capability to treat the condition, the hospital must make arrangements for an appropriate transfer of the patient to another hospital with such capabilities. This is where critical care paramedic interfacility transports come into the picture. The transferring hospital must either stabilize the patient for transport, or the treating physician must certify that the medical benefits reasonably expected from the provision of appropriate medical treatment at another medical facility outweigh the increased risks to the individual given an unstabilized transfer. The stabilizing hospital must provide as much treatment as it can. It must ensure the receiving facility can accommodate the transfer. It must forward all pertinent medical records along with the patient, and the transfer must be effected through the use of qualified personnel and transportation equipment. This includes the use of necessary and medically appropriate life support measures during the transfer. The critical care paramedic is the individual responsible for providing this appropriate transfer from one facility to another as defined by EMTALA. This is a very important law for hospitals, as EMTALA allows for civil penalties of up to $50,000 for a negligent violation of its provisions, and the hospital may also find itself civilly liable to the patient or another medical facility as well. As further clarification, EMTALA defines some key terms as follows. Emergency medical condition is a medical condition manifesting itself by acute symptoms of sufficient severity, including severe pain, such that the absence of immediate medical attention could reasonably be expected to result in placing the individual in serious jeopardy, serious impairment to bodily functions, or serious dysfunction of any bodily organ or part. The law also specifically mentions pregnancy, referring to the health of the woman as well as her unborn child. To stabilize a patient with respect to an emergency medical condition means to provide such medical treatment of the condition as may be necessary to assure, within reasonable medical probability, that no material deterioration of the condition is likely to result from or occur during the transfer of the individual from the facility. Transfer is the movement, including the discharge, of an individual outside a hospital's facilities at the direction of any person employed by or affiliated or associated directly or indirectly with the hospital. If a person leaves against medical advice, it is not considered a transfer by EMTALA. Some legal decisions also further define EMTALA provisions and provide some additional guidance for healthcare facilities. First, EMTALA is not a substitute for a malpractice action. Improper or negligent care remains its own civil action. Emergency stabilization is recognized as short-term only given the available capabilities of the transferring facility. For EMTALA to apply, the patient must have presented to the hospital's emergency department with an emergency condition. An unstable patient can indeed be transferred if the benefits of transferring the patient outweigh the risks. Believe it or not, a transfer by ambulance is not required, although the physician must still ensure the transfer is effected through the use of qualified personnel and transportation equipment, which can change depending on the severity of the patient, the anticipated duration of the transport, and other related factors. Lastly, the plaintiff in the case bears the burden of proof to show that an EMTALA violation occurred. DHS published interfacility transport guidelines in 2006 to clarify who can provide interfacility transportation, to delineate qualifications of staff who provide interfacility transports, and to act as an assessment tool to aid in the determination of how to meet the resource needs for a given interfacility transport. While the document is beginning to show its age, especially in light of updates to EMS statutes and rules since 2006, it still provides some very valuable guidance in terms of the legal expectations for those involved in interfacility transports, from the transferring hospital to the transport team to the receiving facility. While EMTALA addresses the providing of care to patients regardless of whether or not they can pay, the law falls under the Centers for Medicare and Medicaid Services and essentially defines the minimum standard of care for transferring patients between healthcare facilities in general, without consideration as to whether or not the patient has financial means to pay for the treatment. All hospitals are not the same across the state, and there are routine instances in which a patient needs a level of care that cannot be provided by a particular hospital. It is incumbent upon that hospital to recognize the need for a patient to be transferred to another facility for definitive care. An example may be the patient who needs a limb replantation center, a level 1 trauma center, or a burn center. Thus, interfacility transports begin with the transferring facility. The facility must identify both a receiving facility and a receiving physician at that facility. Transfer orders are then generated by the transferring facility in consultation with the receiving physician. These orders will serve as the basis of care for the patient during the transport. With that being said, the facility must also choose the appropriate method of transport for the patient. Because this discussion relates to the transport of critically sick or injured patients, that typically means either air transport, predominantly by helicopter, although fixed-wing aircraft are utilized in other areas of the country, or ground transport via ambulance. Required personnel and life support equipment for the transport are also an important consideration. While critical care paramedics do have training to support the interfacility transport of the critically sick or injured, there may be instances in which a physician or a nurse may accompany a patient on an interfacility transport given a unique set of circumstances. Lastly, the transferring physician must ensure medical treatment and medication orders are provided to the interfacility transport team. These orders must be adequate to encompass the duration of the transfer while also considering reasonably foreseeable complications that may arise. It is also important for the interfacility transport team to understand which facility will be serving as online medical control if the need for assistance arises during the transport. Many of the requirements for critical care paramedic services have already been discussed previously, so we will not go into much depth on this slide. Ultimately, interfacility transport services must be licensed by DHS to provide those services, and their operational plan to do so must be approved by and on file with DHS. The service must have online medical direction in place for interfacility transports, which typically means the service has formal agreements with the transferring hospitals before an interfacility transport is ever provided for the facility. Offline medical control by means of standardized protocols as approved by the service medical director are also required. Do keep in mind, however, that routine pre-hospital EMS protocols do not always apply in an interfacility transport setting. Services providing interfacility transport must ensure their offline protocols account for differences between providing routine on-scene EMS care and transport versus that provided during an interfacility transport of a critically ill or injured patient. While it is not delineated specifically in statute or rule, interfacility transport services should ensure they have adequate malpractice or other insurance to cover their interfacility transport services. This is of significant importance when the agency providing the interfacility transport is a governmental agency. Governmental agencies within Wisconsin enjoy a certain amount of civil liability protection under State Statute 893, capping civil recoveries at $50,000. $25,000 if the agency is a volunteer fire department, or $250,000 if the underlying claim results from a motor vehicle accident. There is case law in the state, however, that stipulates certain immunity protections do not extend to governmental medical personnel. Discretionary acts are commonly afforded immunity, while ministerial duties mandated of the government actor are not afforded such protection. While not prevalent in Wisconsin, some states also remove immunity and civil liability caps for government actions that are routinely a function of private industry. While municipalities in Wisconsin are required to provide emergency medical services, there is no requirement that they provide interfacility transport services, and there are many private providers in the state that provide that service as part of a for-profit business model. Ultimately, critical care paramedic services must ensure they have ample medical malpractice insurance in place to cover the negligent acts of its employees, specifically those involved in interfacility transport services. As far as the critical care paramedic is concerned, his or her primary duty during an interfacility transport is to care for the patient. The critical care paramedic must follow the patient care plan and orders as provided by the transferring physician, adhere to offline medical control protocols as defined by the service and its medical director, to know when to contact online medical control for additional assistance or orders, and also direct the other members of the crew as appropriate, which also means being familiar with the respective scope of practice for those other crew members, as the critical care paramedic cannot direct another crew member to perform a skill or function that is outside that individual's scope of practice. While it goes without saying, the critical care paramedic must also have significant familiarity with the medical equipment that is being utilized during the patient transport, along with any medications that are being or may be administered to the patient during the transport. Because there are numerous vendors and manufacturers of medical devices and equipment, the critical care paramedic must be trained in the use and troubleshooting of the specific piece of equipment being transported with the patient. Also, unlike paramedics, critical care paramedics are able to obtain just-in-time training on any medication being administered to the patient. This means that the transferring physician can provide training to the critical care paramedics on the medication, its indications, actions, contraindications, side effects, dosage, and of critical importance, what should be done if any problems arise during the transport. This information is especially critical if multiple medications are being administered at one time. If you can remember back to your initial EMT or paramedic education, the term abandonment must also come to mind within the context of interfacility transport responsibilities. The interfacility transport service and, by extension, its critical care paramedics and other personnel must ensure the patient is indeed transported and transferred to the destination facility without interruption in the continuum of care. This means that there must be a formal transfer of care to the patient's new receiving physician or associated staff. The patient should also never be left unattended. If the ambulance only has two people, one driver and one attendant, that means the person in the back of the ambulance cannot exit the patient compartment and leave the patient alone to help spot the driver while backing up the ambulance. If the ambulance driver is required by the service to have a spotter when backing up the ambulance, other arrangements must be made, or the driver should simply not back up while the attendant or another individual is unable to assist with spotting the driver while he or she backs up the ambulance. Given that the patient is being entrusted to the care of a critical care paramedic during transport, that also means that the critical care paramedic must remain in the back of the ambulance with the patient at all times. This means that the critical care paramedic cannot drive the ambulance during the interfacility transport, leaving the lower trained paramedic or EMT in the back of the ambulance with the patient. Those types of occurrences could give rise to an abandonment lawsuit. Lastly, documentation is extraordinarily important in critical care interfacility transports. While documentation is vital for all EMS transports, the importance in critical care interfacility transports is of increased significance because the transporting unit needs to convey the patient documentation from the originating facility to the receiving facility. Remember from earlier in the presentation that EMTALA requires a transferring facility to provide all patient care records related to the current ailment to the receiving facility. It is also critical for the transporting unit to document the patient's condition upon initial transfer, during transport, and upon transfer to the destination facility. This includes noting the patency of intravenous or central lines, proper placement of airway adjuncts, working condition of medical equipment, amount of medication and fluids already infused, programmed drip rates, and other related data. While it is not the goal of the critical care paramedic to think in such terms, if a medical error is made by either facility, the transporting crew's documentation is absolutely critical in alleviating liability on the part of the critical care paramedic service, while also providing clues as to where the error may have occurred. Additionally, the critical care paramedic must ensure his or her documentation contains the name of the transferring physician, any orders received at the time of transfer or during the transport via online medical control, any change in patient condition during the transport, any interventions performed during the transport, any complications experienced during the transport, and the name of the staff who assume patient care at the receiving facility, preferably a receiving physician. Any items documented within the report must be accurate because they must correlate with the documentation provided by both facilities both before and after the transport. It is also vital that the name of the person performing interventions in the back of the ambulance during transport also be documented accurately if more than one person is in the back of the ambulance with the patient. Ultimately, the critical care paramedic's documentation generated as a result of the interfacility transport will become part of the patient's permanent medical record. It is very important that the documentation be accurate, professional, and well written. Every EMS provider in the state should be familiar with advanced directives, as the topic is included in the initial education for all licensure levels. With that being said, the critical care paramedic has a greater likelihood of encountering unique situations with regard to patient end-of-life decisions that do not always arise in the field. For that reason, a review of the different advanced directives available within Wisconsin, along with their application to the critical care paramedic, is prudent. The first type of advanced directive in the state is the Declaration to Physicians, otherwise known as a living will. Under State Statute 154.03 sub 1, any person of sound mind and 18 years of age or older may, at any time, voluntarily execute a declaration authorizing the withholding or withdrawal of life-sustaining procedures or feeding tubes if the person suffers from a terminal condition or enters a persistent vegetative state. If the patient's attending physician believes that the withholding of life-sustaining procedures or feeding tubes will cause the patient pain or reduce the patient's comfort and the pain or discomfort cannot be alleviated through pain relief measures, the physician can indeed perform life-saving measures, administer medication, or maintain a feeding tube. The patient may not authorize the withholding or withdrawal of nutrition or hydration that is administered or otherwise received through means other than a feeding tube unless the attending physician believes, in his or her professional judgment, such administration is medically contraindicated. Once the attending physician is aware of such a document, it shall become part of the patient's medical records. State law also recognizes the validity of similar instruments if executed in another state and compliant with Wisconsin provisions. The patient can revoke the Declaration to Physicians document at any time by canceling, defacing, obliterating, burning, tearing, or otherwise destroying the document. The patient can also revoke the document by directing someone else to destroy the document in such fashion while in the patient's presence. The patient can also draft a written revocation, or the patient can express his or her wishes to revoke the document verbally to the attending physician. If an interfacility transfer patient has a declaration of physicians on file with the originating facility, that should be communicated to the transporting service, and orders should be in place to address what happens if the patient's condition does deteriorate during transport. Remember that the critical care paramedic is acting as an extension of the physician, assuming medical control for the patient. Typically the transferring physician, although it could be the receiving physician based on the circumstances. It is up to the two facilities to determine that prior to the interfacility transport, and that there are limited situations in which the attending physician can choose to not follow the patient's wishes. The law does provide both civil and criminal immunity protection for anyone following the patient's wishes under a valid declaration to physician's document. Power of attorney for healthcare is when another person essentially stands in the place of the patient for making healthcare decisions on behalf of the patient. Unless the document specifies otherwise, the power of attorney for healthcare does not become effective until at least two physicians, or one physician and one licensed psychologist, establish the patient's inability to receive and evaluate information effectively or to communicate decisions to such an extent that the individual lacks the capacity to manage his or her healthcare decisions. If the patient, him or herself, retains capacity for making decisions, those decisions will always supersede those of his or her power of attorney for healthcare. Because the power of attorney for healthcare simply makes healthcare decisions for the incapacitated patient, it should not be surprising to hear that the limitations for power of attorney for healthcare are similar to those in the Declarations to Physicians statute, namely as the provisions refer to the withholding of life-saving measures or a feeding tube. The attending physician may choose to not follow such direction if, in his or her professional opinion, it will cause the patient pain or discomfort that cannot be managed. The competent patient can revoke a power of attorney for health care in somewhat similar fashions to a declaration to physician's document. Verbal revocation must be made in the presence of two witnesses, however. The law also provides criminal and civil immunity to those healthcare providers following the legal direction of power of attorney for health care. Lastly, Subchapter 3 of State Statute 154 provides for the use of do not resuscitate DNR orders. Within the scope of providing interfacility transport services, it is important to recognize that a DNR order does not necessarily mean a DNR bracelet. DNR orders can exist within healthcare institutions without the patient wearing a DNR bracelet. To receive a DNR order, the patient must be at least 18 years of age, must not be pregnant, and must have a terminal condition or some other medical condition where CPR will result in significant physical pain or harm that would outweigh the possibility of the efforts restoring cardiac and/or respiratory function for an indefinite period of time, or where repeated cardiac and/or pulmonary failure would be expected within a short period of time after resuscitation efforts. Only the patient's attending physician can issue a DNR order. EMS providers, including critical care paramedics, are required to follow DNR orders unless the order is revoked or the patient is known to be pregnant. EMS providers in the field are also able to ignore DNR orders if the patient's DNR bracelet has been tampered with or removed. Because the critical care patient may not have a DNR bracelet, the absence of a DNR bracelet does not alleviate the critical care paramedic's duty to follow the legal DNR order. A patient may revoke a DNR order by verbally expressing his or her wishes to the EMS provider, by defacing, burning, cutting, or otherwise destroying the DNR bracelet, or by the patient asking another person to remove the DNR bracelet. Again, because the patient on an interfacility transfer may not have a DNR bracelet, verbal notification is probably the most likely way he or she will express such wishes if indeed the patient is in such a position to verbalize such a request. Any revocation must be recorded by the EMS provider, and the attending physician must be notified as soon as possible of the revocation. The time, date, and place of the revocation must be noted in the documentation. Administrative Rule HFS 125.05 sub 4 is also very clear that the patient's DNR desires are paramount to the wishes of family or friends. It is also important to note that while EMS providers are not to perform life support measures on a patient with a valid DNR order, they may still provide comfort care to the patient. Such comfort care includes oxygen administration, clearing the airway, bleeding control, emotional support, splinting, positioning for comfort, and pain control. As with other forms of advanced directives, EMS personnel are protected from both civil and criminal liability for following the patient's DNR order. So long as the provider is functioning in good faith and lacks actual knowledge of a DNR order, that liability protection also extends to the provider who fails to comply with a DNR order. With that being said, if the critical care paramedic knows of the DNR order and takes life-saving measures anyways without a revocation from the patient, there is no immunity protection provided, and the critical care paramedic could be found civilly or criminally liable for his or her actions. Essentially, all of these legal provisions are designed to recognize an individual's right to self-determination. Competent adults cannot be forced into receiving medical treatment against their will, and along those lines, they also have the right to die with dignity, as the expression goes. While affirmative acts taken to end life are illegal, suicide, the law does protect the right of a patient to experience the natural process of dying without having to be subjected to external life-saving measures if that is indeed what the patient wishes. These orders are not considered suicide by the law, and healthcare providers are protected both civilly and criminally for following the patient's legal end-of-life wishes. If you think back to your initial EMS education, this relates to discussions on patient competency and consent. While we will not delve into the topic of consent in this presentation, given that the topic was covered in your initial EMT and paramedic education, remember that a competent adult patient can consent to treatment, refuse treatment, or limit the type or amount of treatment received. Just because a person is dying does not mean he or she loses those personal autonomy rights. Advanced directives provide a means by which the patient can still convey his or her end-of-life wishes to healthcare providers in the event of a serious illness or other incapacity. The flip side of this advanced directives coin is what must be done in the absence of such directives. Unless directed otherwise by the attending physician in the patient care plan or online medical control, if a patient codes during an interfacility transport, the transport team is required to provide resuscitative measures. This includes rescue breathing in the event of a respiratory arrest or full CPR if cardiac arrest occurs as well. For anyone involved in EMS long enough, it is an eventual certainty that a patient will die while in the provider's care. For the critical care paramedic, this is even more likely as the patient is already critically ill or injured to the point where a hospital, which has more personnel and equipment resources than the back of an ambulance, feels it necessary to transfer the patient to another facility for more significant care. In some instances, the distance from the transferring hospital to the receiving hospital may be considerable, which increases the odds of patient mortality. The sad fact of the matter is that there are cases in which the hospital knows the patient will die if not transferred, and the risk of the patient dying during the transfer is acceptable to give the patient a chance of survival at another facility, even if that chance is a small one. This means that the critical care paramedic may find him or herself in a race against the clock to reach a definitive healthcare center before the patient loses all hope for survival. Given the increased likelihood for patient mortality, it is incumbent upon the interfacility transport team to ensure they are aware of any advanced directives in the patient's medical record, or, in the absence of such advanced directives, what the attending physician wants done if the patient's condition deteriorates to the point where life-saving interventions are required to sustain life. Depending on the totality of the circumstances, there may be instances in which the physician may not want heroic measures taken even in the absence of advanced directives. In such an unfortunate case, the next question is where the decedent's body should be transported. If the ambulance is still several hours away from the destination facility, does it make sense to transport a dead body that far, especially if the transferring facility is still closer? This is something that must be addressed as well. On the other hand, as discussed previously, if the patient's condition requires CPR, it may be necessary to divert to a closer facility if the transporting time to the receiving facility is significant. Related to this discussion on patient mortality is the state law that addresses the disposition of human remains, State Statute 157. Under 157.06 sub 12, any EMT who reasonably believes an individual to be dead or near death shall make a reasonable search of the individual for a record of gift or a record of refusal or other information identifying the individual as a donor or as an individual who has refused to make an anatomical gift. This is something that should have been already addressed by the transferring hospital, but if not, The critical care paramedic has a legal obligation to see if the patient is indeed an organ donor. If that is the case, the untimely death of the patient in the ambulance may result in a continuation of transport to either the same or a different destination for the purposes of organ harvesting. All levels of EMS providers receive training on the ethical aspects associated with providing emergency medical care. For the critical care paramedic, these ethical responsibilities are no different. As a result, this discussion will not delve too deeply into the ethical responsibilities of EMS providers, as the critical care paramedic should already be familiar with those expectations. As a refresher, ethics are defined as self-imposed standards or rules that govern the conduct of a group, profession, or society. This is in contrast to morals, which govern conduct on an individual or personal basis. It is also important to note that just because an activity is legal does not necessarily make it moral or ethical. The recent housing bust and recession in 2008 is an example of questionable ethical conduct in the absence of laws to prohibit such conduct. Legally, EMS providers are required to provide for the physical well-being of their patients. Ethically, that responsibility also extends to the patient's emotional well-being, as well as that of his or her family and, quite possibly, friends. While critical care paramedics will not be entering patient homes given the nature of interfacility transports, it is not unusual for the interfacility team to transport personal belongings along with the patient from the originating facility to the destination. Ethically, the critical care paramedic must ensure the safekeeping and transport of those personal effects along with the patient. Document what was received and that all personal property was transferred to the receiving facility along with the patient. While the critical care paramedic is better insulated from the involvement of the patient's family and/or friends in healthcare decisions, as opposed to an EMS provider responding to calls for service out in the community, it is still important to recognize the importance of patient self-determination and personal autonomy. Just because the family wants something done to preserve or prolong the patient's life does not automatically mean the patient would want it done. Advanced directives go a long way in resolving such conflicts for healthcare providers. In the absence of such directives, however, things can become much more nebulous. One family member may want the patient's life preserved at all costs to avoid suffering their own personal loss. On the other hand, another family member may want to see the patient die sooner rather than later to benefit from life insurance proceeds or other transferable assets. Some family members may have the patient's best interests at heart, while others have more dubious reasons for desiring a particular outcome. Ethics dictate that EMS providers serve the patient's best interests. There are also instances in which the law will define what the EMS provider must do based upon advanced directives, court orders, next of kin determinations, and other factors. The good news is that the critical care paramedic is commonly shielded from having to make such decisions, as he or she will be functioning under the orders of a physician when caring for the interfacility transfer patient. In many instances, a critical care paramedic's ethical duties intersect with legal obligations. Ethically, the critical care paramedic must ensure he or she maintains competence by obtaining ongoing continuing education and training. The critical care paramedic must provide competent care to his or her patient by complying with protocols, orders, and standards of care. The critical care paramedic must also consider his or her impact on the community at large, such as the ethical responsibilities to educate, participate in public health initiatives, and drive with due regard, even if transporting with lights and siren. Ultimately, it is important for you as a future critical care paramedic to practice in such a fashion as to reduce legal liability whenever possible, while also providing the highest level of care to your patient, which will also help reduce exposure to legal liability. While many of these components will be discussed in much greater detail within the critical care paramedic course, what follows is a bullet point list of tips to follow in your practice to help reduce your exposure to legal liability. Upon arrival at the transferring facility, be certain to obtain a full patient history from the patient's current healthcare provider. Ensure the patient has a patent and secure airway. If the patient is intubated, check and document the depth of the endotracheal tube. If IV or central line access has been obtained by the hospital staff, make sure they are patent and properly secured. Also ensure that appropriate measures have already been taken to treat any hemodynamic instability. If there is a concern that the incapacitated patient, referring to legal capacity, may interfere with his or her own care, the patient should be properly restrained either chemically or physically as appropriate. Make sure the patient is being monitored appropriately, which could include ECGs, end-tidal CO2, fetal monitoring, pulse oximetry, and other appropriate vital signs. If the patient suffered trauma, affected joints and/or bones should be properly immobilized if required. This could also include spinal immobilization. In preparing to assume care of the patient, ensure you know the reason for the transfer along with the name and location of the receiving hospital and physician. If the transferring hospital will be sending staff along with the transporting unit, be familiar with their areas of expertise along with their respective anticipated roles during the transport. Be sure to know what treatments have been provided thus far and how the patient has responded to those treatments. Obtain the medical treatment and medication orders for the upcoming transport, ensuring those orders are adequate to address the full duration of the transport. Also be sure to find out what complications may be anticipated given the patient's injuries or illnesses in conjunction with any treatment that has been or will be provided. Perform your own assessment of the patient, looking for any issues that should be addressed by the transferring hospital before transport begins. Ensure you know who will function as online medical control for the transport. Because it is not unusual for hospitals to utilize medications not commonly carried on an ambulance, be sure the hospital provides enough medication to last for the anticipated duration of the transport if the ambulance does not have its own adequate supply. Under EMTALA, the transferring hospital is required to forward all pertinent documentation to the receiving facility. This information must include any pertinent records of the current emergency condition, including the patient's signs and symptoms, diagnoses, treatment provided, and any test results such as CAT scans, blood work, x-rays, etc. A copy of the patient's written consent to transfer, or an equivalent if the patient is incapacitated, along with the attending physician's verification that the benefits of the transfer outweigh the risks associated with the transfer, should also be transported along with the patient. During transport, the critical care paramedic must not only monitor vital signs, but be sure to document them along with the time they were obtained and who obtained them. Provide respiratory and circulatory support as necessary, and ensure adequate fluid volume replacement if indicated. If medication is being infused, be certain to check it frequently to ensure adequate and appropriate delivery. If medications are delivered manually, be certain to document the dosage, route, time, who administered, and the patient's response to the medication. Reassess vitals shortly afterward and also document why the administration was necessary. Was it in the transferring physician's orders? Was it part of a standing protocol? Or was there direction provided by online medical control? Be certain to maintain adequate communication with medical control, providing updates and seeking direction as necessary. Be certain to document those contacts as well, including the time of the contact, who you spoke with, the reason for the contact, and any orders received during the contact. If not clear already, be certain to document everything thoroughly. Once you reach the destination facility and are in the process of transferring patient care to the receiving physician and hospital staff, a verbal patient transfer report should be provided. Within that report, be sure to convey the patient's name and age to the staff. If gender is ambiguous, referring to the patient as him or her should be ample to convey the patient's gender. Confirm the name of the transferring physician and facility along with the reason for the patient transfer. Provide a brief review of the patient's history, medications administered, fluid intake, and a summary of the patient's condition during transport. Did the patient's condition improve, worsen, or remain relatively stable during transport? Did the patient have any adverse responses or reactions to medications or other treatments? If so, be certain to share that information. Be certain to physically hand any specimens, records, and/or test results to the appropriate staff along with any of the patient's personal effects, and also document that such items were transferred to the receiving facility along with the name of the staff person who received them. If the receiving facility has any questions, be certain to answer them to the best of your ability. If you do not know the answer to a specific question, relay that information as well. Do not guess, assume, or make something up. Once the receiving facility assumes care of the patient, take the time to ensure your interfacility transport care report is complete, accurate, and well written. Ensure proper spelling, grammar, and use of punctuation. Remember, this report will be part of the patient's permanent medical record, and in the event of future litigation, the quality and content of your report could have a significant impact on the outcome. Other items that must be included are the times associated with each set of vital signs and assessment findings. Provide the times and details of each intervention performed, including the name of the crew member who performed them, not the crew member who documented them unless that is the same person. Describe any patient responses to the interventions performed, especially if the responses are negative. Document any communications with medical control, including the time of the contact, which facility was contacted, the name of the person contacted, and any orders received. If there were any deviations from the transfer or standing orders, document those deviations, why they were performed, who authorized the deviations, and how the patient responded to them. If it was necessary to divert the transport to another closer or more appropriate facility, document why the decision was made along with medical control's approval of the diversion. Given a conscious and competent patient, it is possible for the patient to refuse any intervention or procedure. If that occurs, be certain that the refusal is an informed refusal by providing the patient with information as to why the intervention or procedure is necessary, the risks associated with the intervention or procedure, as well as the risks associated with not having the intervention or procedure performed. If the patient still refuses the intervention or procedure, be sure to document the information you provided to the patient along with his or her refusal to the intervention or procedure. To put these legal and ethical principles into perspective, consider the following scenario. A local ambulance crew responded to a residence for an unconscious patient. Upon evaluation, the crew determined the patient was hypoglycemic with a blood sugar of 25 milligrams per deciliter. The crew started an IV and administered 25 grams of dextrose via IV push. This raised the blood sugar to a reading of 73 milligrams per deciliter with a marginal improvement in the patient's mentation. At the hospital, the patient was again unresponsive with a blood sugar of 35 milligrams per deciliter. According to the hospital, the patient's insulin pump had malfunctioned. Documentation from the EMS crew indicated they knew about the pump, but medical control told them to not touch the pump and transport immediately while treating with dextrose. The transport time from the scene to the hospital was relatively short. The hospital disconnected the pump and placed the patient on a glucose drip after another bolus of dextrose was administered. Unfortunately for this patient, diabetic complications were only a piece of the puzzle. The patient was also suffering from pneumonia and sepsis. BiPAP was administered along with antibiotics and vasopressors. Due to the rural location of the hospital, it was determined that the patient needed to be transported to a larger facility in a nearby city for continued treatment and management of her ailments. An interfacility transport was utilized, and according to the interfacility transport report, the 20-minute transport was uneventful. Approximately 45 minutes after the patient was received by the destination facility, an ICU nurse noticed that the IV had infiltrated and, due to the glucose drip, tissue necrosis was present. While the patient ultimately survived the hypoglycemia, pneumonia, and sepsis, the tissue necrosis from the glucose infiltration was so bad that the patient's arm had to be amputated. To add insult to injury, the patient was a rather successful local musician, and given the loss of her arm as a result of this medical negligence, her financial losses were calculated to be very significant. The original EMS unit, the initial hospital, the interfacility transport unit, and the receiving hospital were all sued by the patient for financial damages and emotional distress given the loss of her arm due to medical malpractice. All those responsible for the patient's care were personally named in the lawsuit as well. For the purposes of this case study, the original transporting EMS unit documented that the IV was patent and flowing when the ED received the patient. This was confirmed by ED documentation as well. With that information, the original EMS unit and its personnel, who were all named personally in the lawsuit, were removed from the lawsuit. The documentation from the transferring hospital prior to the interfacility transport indicated that the IV line was patent and infusing at the designated rate. The documentation for the interfacility transport service did not document the status of the IV upon receipt of the patient. It also failed to include information on the status of the IV during transport or upon delivery of the patient to the receiving facility. The documentation from the receiving facility also did not specifically identify or describe the infusion site. The first time the infusion site was mentioned in any documentation was approximately 45 minutes after the patient was received at the secondary facility when the necrosis was noticed by the ICU receiving nurse. Based on the documentation from the originating hospital and deposition testimony, it was determined that the infiltration did not occur at the initial hospital, and they were removed from the lawsuit as well, leaving the interfacility transport service and the receiving hospital the remaining two defendants in the lawsuit. Given inadequate documentation from both the interfacility transport service as well as the receiving hospital, along with questionable recollections of those who provided care to the patient, there was no clear way to determine where the medical error occurred. In the end, the jury determined that the hospital was 2/3 responsible for the patient's losses and the interfacility transport service was 1/3 responsible. The patient's recovery against the two organizations totaled over $1 million. Despite the financial recovery, the patient was no longer able to perform as a musician and, after a lengthy bout of depression, alcoholism, and substance abuse that began shortly after the amputation, the patient suffered an untimely death due to a prescription narcotic overdose. Believe it or not, this case study is actually based on an actual case in another state where a patient lost an arm due to tissue necrosis from glucose administration where an IV infiltrated. It should still be considered a hypothetical case, however, as several details were modified for illustrative purposes. The case did indeed involve the four entities listed: an original EMS unit, the initial treatment hospital, an interfacility transport unit, and a receiving hospital. In the end, due to a lack of adequate documentation on the part of the critical care transport unit, it was unclear whether the infiltration occurred before, during, or after the interfacility transport, and the interfacility transport unit did share some responsibility for the patient's loss. In the scenario presented, who do you think is responsible for the loss of the patient's arm? Arguably, it is not clear when the IV infiltration occurred. If it happened at the original hospital, do you believe this should have been noticed by the critical care paramedic? Remember before how it was stated the critical care paramedic should perform his or her own assessment of the patient before assuming care of that patient from the transferring facility. Part of that assessment should include confirmation that all current interventions and equipment are appropriate and working correctly. In this instance, the problem was an infiltrated IV. This could very easily have been an endotracheal tube that dislodged during patient movement, an infusion pump failure, or any number of other complications. Assuming everything was fine when the patient was received from the transferring facility, it is incumbent on the critical care paramedic to constantly monitor and periodically reassess the patient, the frequency of which could vary based upon the patient's specific condition and circumstances. Any issues that occur should be documented. When the patient is delivered to the receiving facility, the critical care paramedic should once again reassess the patient and verify the effectiveness of ongoing interventions, such as an IV. The patient care report should include information as to the patient's status upon transfer to the receiving facility. The patency of an airway adjunct or an IV should be included in that documentation. Beyond that point, there is not much else the critical care paramedic can do. In this particular scenario, if the infiltration occurred during patient movement after the receiving facility assumed patient care, the responsibility for the incident would clearly fall on the hospital and its staff. In this particular instance, however, there was no documentation on the part of the interfacility transport team to determine one way or the other when the infiltration occurred. The problem in such a scenario is that a patient has anywhere from 1 to 5 years, depending on the circumstances, to file a medical malpractice lawsuit in Wisconsin. Once filed, the discovery process in which the parties perform their fact-finding through depositions, requests for documentation, interrogatories, and other means could take several years as well. Unless the transport is documented thoroughly and appropriately at the time of the transport, it is unlikely the critical care paramedic will remember the details of any single transport years later to mount a substantial defense to a medical malpractice or negligence lawsuit. In this particular instance, it is difficult to determine whether or not the critical care paramedic breached a legal duty to the patient because it is unclear when the infiltration occurred. With that being said, the critical care paramedic also owed an ethical duty to his or her employer, and the failure to appropriately document the transport resulted in significant liability exposure. Along somewhat similar lines, the failure to document appropriately probably would contribute to a much longer legal process as it introduces ambiguity into the case. If it was clear from the documentation that everything was fine when the critical care unit transferred the patient to the receiving facility, the resulting lawsuit would probably not last as long because there would be very little debate as to what entity is responsible for the patient's injuries. This could provide greater impetus for the receiving facility to settle the lawsuit amicably rather than fighting because it thinks the interfacility transport unit is responsible for the patient's injuries. This lengthens the process for everyone involved, including the patient. Ethically, the critical care paramedic wants what is in the patient's best interest and strives not only to do no harm, but to also make things better. The care provided, in conjunction with the lack of adequate documentation in this case study, failed to meet this goal. If you are reviewing this presentation as a part of a formal critical care course offering, you may have access to a critical care transport or critical care paramedic textbook with additional case studies provided. Be certain to review those cases as well, if available, for additional perspective on the legal and ethical issues inherent within the practice of being a critical care paramedic. Ultimately, it is not uncommon for EMS providers to go an entire career without being involved in litigation. All it takes is once, however, and the critical care paramedic will never question the value of providing exceptional service and documenting everything thoroughly. Meeting ethical and legal responsibilities while thoroughly documenting every transport can go a long way in reducing legal liability exposure for both yourself and your employer. More importantly, the end result of such practices should be a better patient care experience. Given your completion of this module, you should now be able to recognize basic legal issues pertaining to critical care transports, identify federal and state laws governing interfacility transports, explain the respective roles, duties, obligations, and responsibilities of the transferring facility, receiving facility, interfacility transport service, and the critical care paramedic. Summarize EMTALA and its requirements as they apply to the interfacility transferring of the sick and injured. Differentiate the various types of advanced directives available within Wisconsin, and explain ways to minimize legal liability and exposure while providing interfacility transport services. To summarize, remember that the legal considerations discussed within this presentation exist for the benefit of everyone involved in interfacility transports. Your patient benefits from higher quality care, while your service, the hospitals, and yourself benefit from clear guidelines on how to function that should help reduce overall exposure to legal liability if followed. Being aware of not only your legal responsibilities, but also your ethical obligations to the patient, your service, and the public will also provide you with guidance in your practice as a critical care paramedic. If you have any questions related to this material, please be sure to reach out to your instructor for additional assistance. Thank you for watching this presentation on the medical, legal, and ethical issues associated with being a critical care paramedic in Wisconsin. This presentation was created by Waukesha County Technical College with grant funding from the Wisconsin Technical College System.